So we're continuing our discussion of Métis rights, and today we're going to be dealing with the Powley case and the Manitoba Métis Federation case. And the purpose of this is to explore two different dimensions of Métis rights. One, Métis rights that aren't necessarily related to land, the Powley case. Also to look at the honor of the Crown and how it's interpreted in the Métis context. And we've got here a picture of Mr. Powley, who was the person at the center of the case dealing with hunting moose in the Sault Ste. Marie area. He, on an early morning, it looks like, shot and killed a bull moose near Sault Ste. Marie. He took this moose to his home and he put a tag in its ear that said that it was in handwriting under the authority of the Ontario Métis and Aboriginal Association that he took this moose. He wrote his membership number from the Ontario Métis Nation on the tag. And this was because he didn't have a tag as required if you're an Indian hunter from the Ministry of Natural Resources, which would allow you to take a moose at any season. So because he didn't have this tag as required by the Ministry of Natural Resources, he only had his own tag that he said was there in accordance with his Métis membership, he was charged with violating the Game and Fish Act, which prohibits hunting moose without a license. Now he argues that he has a Métis right to hunt this moose, and the provincial law is an infringement on his right that is not justified in the circumstances, and therefore he claims a defense of a Métis right to the charge of the violation of the Game and Fish Act. So that's the background to the case. That's another one of these resource use cases. Here's the architecture of the case that we're going to go through, just the outline. We're first of all going to talk about how, in considering Métis rights, we can't just pull Vanderpeet across completely as a 100% analogy, because you remember that Vanderpeet protects Aboriginal and treaty rights prior to the arrival of Europeans that are integral to the distinctive culture of Aboriginal communities. Well, there were no Métis people prior to the arrival of Europeans. Métis people arose as a result of the intermixture between Europeans and other Aboriginal peoples, and therefore Vanderpeet's going to have to be modified, and we'll look at that. The court then characterizes what's being claimed here as not a right to hunt for moose, but a right to hunt for food. Then the court considers this particular group, which is not that Red River Genesis that we mentioned earlier. And so there's a need to identify an historic Métis community to which Mr. Powley can attach his claim. It's not enough to say that he's a member of the Ontario Métis and Aboriginal Association. That's not sufficient. He has to find a particular historic community, not a kind of public political group to attach his rights to. That historic community also has to be identified with a continuity, right? We saw that in the Aboriginal title context, that there has to be a contemporary community that also claims a relationship to that historic community. And so we'll look at that. We'll also then look at his relationship to the community, this historic and continuing Métis community, through principles of self-identity, ancestral connection, and community acceptance. And then once we've got the community down, once we've modified Vanderpeet to identify community and find his relationship to this community, we're going to ask for the test for the proof of Aboriginal title. When's the exact date when the Métis rights arose? And then whether hunting moose itself then is integral to a distinctive Metis culture, and then finally looking at issues of continuity of the right, which the court finds that there is, and the court also finds that this right is not, that is the right to hunt moose, is not extinguished. So in other words, Mr. Powley is successful in his defense in claiming that and proving that he has a Métis right to hunt out of season. He doesn't need the license that's issued by the Ministry of Natural Resources because he's able to establish that he meets the characteristics that we're going to talk about now in more detail as we go through this case. You see what we're talking about here too, right? Sault Ste. Marie is Powhatan in Anishinaabe. It's the rapids there. That's an historic Ojibwe homeland. At those rapids, whitefish flow through that little strait there in great numbers. And so Ojibwe people gathered to trade there for thousands and thousands of years. And when Europeans came along, they took advantage of that pre-existing gathering place, that pre-existing place of trade, and then eventually intermarriage or reproduction occurred, and you get the settlement and development of a Métis community next to that Ojibwe Anishinaabe community there. So the first part of the decision is in paragraphs 10 to 18 in the materials in the Powley case, and we're discussing the idea of the modification of the Vanderpeet principles. We're trying to figure out what is being constitutionally protected. And the court says that there is a distinctive Métis place in Canada, and there's actually a diversity of Métis groups. So this might not make some of those people who are Red River Métis nationalists very happy, because now we can find that there are other places where there's what the court's going to call an ethnogenesis of Métis people. So it's not necessary to show connection to the Red River to claim Métis rights, is what is significant about this paragraph, the identification of this distinct cultural diversity of Métis groups. And the court quite frequently in this decision cites the Royal Commission on Aboriginal Peoples, and you might have noticed through the entire course so far that sometimes that stands as much authority as a past Supreme Court judgment. That 6-volume, 5-year task actually does continue to guide and direct our laws. Sometimes it said we don't need national inquiries on particular issues. We already know the answers to these questions that Frayne has sometimes put. This illustrates that even if government doesn't necessarily act on what's there in those inquiries, in those reports, they can have significant judicial weight because of the consultation, the fine academic standards that are put into this. I mean, on this commission were 2 former members of the Supreme Court of Canada as it was proceeding. Justice Wilson and Justice Dixon were there, as well as a former member, Grand Chief of the Assembly of First Nations, Quebec Court of Appeal judge, Métis scholar, First Nations scholars. So that is important just to note here as to why you keep seeing RCAP referred to so strongly. The court has to modify, as we talked about just in the case architecture, the Vanderpeet case, to reflect the post-contact ethnogenesis of the Métis people, again, because they weren't there prior to the arrival of Europeans. The court says that Métis culture, therefore, is not traceable to contact or pre-contact. It grew pre-colonization. Métis cultures, Métis nations grew pre-colonization and post-effective, actually be pre-effective European control. That should be pre there. that's backwards. A group post-colonization, pre-effective European control. Is that right? Yeah. So just switch the pre and the post there to make that make sense. So after contact, you've got this development of Métis people before Europeans actually are able to sustain their own claims in an area, which raises some questions. First of all, going to the ethnogenesis post-contact, but pre-effective European control. Why, in the contemporary circumstances, might not a new Métis group be able to receive constitutional protection? So say, 20 years ago or 20 years from now, Aboriginal peoples intermarry with another group or groups, and through that intermarriage, they start to develop distinctive songs and stories and language and understandings of their relationality in that place. Why is it that we want to put Métis rights back to pre-effective European control? What is it about, what's the court concerned about in terms of Aboriginal groups suddenly arising now? Because in the past, Aboriginal groups would arise all the time. Yes, I talk about the Ojibwe Nation or the Cree Nation, or we can talk about the Coast Salish and Strait Salish people, but they weren't always referred to in that way. They themselves had their own distinctive sort of histories. Yes?
Well, it seems like maybe there's just a concern about delineating, because if groups are arising all the time, and then it's like, well, what if there's one family that's half First Nations, half white, they start claiming their rights, and then I think the court's probably just concerned about having just a whole lack of constitutional cases that they can't deal with.
Okay, so there's an administrative efficiency issue here, a floodgates argument. If people started being able to claim Aboriginal identity in the present, there's the worry of the benefits that might need to be extended, or the distinctive treatment that might be needed there as one point. And I think you made another point too, which is there could be kind of a divide and conquer that could occur in this, just groups continuing to splinter from one another and then not having a solidity and a certainty around who are Aboriginal peoples in Canada such that these rights can attach to. Other thoughts? Yes.
It just feels very constraining that your culture, so Métis culture would only, you can only look to a 50-year period of development. It's one generation of rights, and so I think it really constrains how the actualization of those rights, and so just preventing development of title and rights claims.
Yes, so there is a constraining function here that may be limited to 1 or 2 generations of people being able to claim rights as Métis people prior to effective European control. And that kind of constraint might not necessarily be consistent with the Indigenous legal traditions in terms of allowing for a kind of freedom in how people develop their identity and find their relationships with the land. And then again, that might be all well and good for administrative efficiency purposes if you're the federal or the provincial government. It might also be helpful for those established Métis and Indian groups to make sure that you don't get continual split-offs and other groups being formed. I get that. But there might be something too about this that kind of freezes the way people view their identity and lock them into sort of one way of being that could be against the historic flow and their own preferences as to how they identify.
I'm not saying I agree with this, but I think if Métis groups are allowed to claim rights that have evolved over time, whereas the First Nations people wouldn't be able to do the same because they're constrained by the point of contact.
Okay.
That could seem unfair. I mean, the counter argument is why not let them all have rights that are evolving. But that I could see if they were held to different standards.
Yes, this is an interesting point. There could be potentially different standards if Indians are always frozen at the time of contact, but Métis can forever, post-contact, develop new communities, new rights. That inequality between how Indians and Métis people are treated could be a problem constitutionally, although you make the point that partly that could be dealt with by allowing Aboriginal peoples as Indians to also develop a new Ojibwe community somewhere, or find a new kind of ethnic genesis in the future. Yes.
So if people just followed their genealogy, could they not just become whoever they're identifying with?
So this is the question that the court raises: is what is the significance of genealogy in understanding Métis rights? And they are going to go to the point that as long as you have some lineal descendancy from a Métis ancestor with self-identity and recognition of a community, you're okay. But the court's saying new communities can't form to do that. It has to be these other historic communities. Now, this is also an interesting point. The court says that Métis culture grew post-colonization, pre-effective European control, which kind of implies that now Métis people are under the control of Canada. And libertarian Métis people might not view that as a part of their culture. They call themselves the independent ones. Now, the characterization of the right here is discussed in paragraph 19, and the trial judge determined that Mr. Powley and his companion here were hunting for food. There was an argument by the Crown that the proper characterization should be hunting for moose. And because moose weren't actually plentiful at the time of this Métis ethnogenesis, the court was saying, the Crown was saying, that they don't have this right to hunt for moose because moose weren't around. And the court rejects that point of view. In paragraph 20, says, "We agree with the trial judge that the periodic scarcity of moose does not itself undermine the Métis claim. The relevant right is not to hunt moose, but to hunt for food in the designated territory." And moose just happen to be one of those things that you can get in that territory from time to time, even though it was scarce at certain periods in the past. This kind of is a little different from the way we often see rights being characterized, where you try to drill down to the most specific particularity of what's being claimed. There's a little bit more generosity in the framing of the characterization here. Yes?
Is that how they frame it? I'm trying to remember in Vanderpeet, it wasn't a right to, like it was a right to fish, like it wasn't a right to collect food from the ocean. I'm wondering why that was the
Yeah, this doesn't seem to square with Vanderpeet. Again, remembering Vanderpeet was a claim to exchange fish for goods, and there was too broad a characterization to be able to sustain. So there's something different about this characterization here. Then the court says we have to identify an historic rights-bearing community. And the trial judge found that a distinctive Métis community emerged in the Upper Great Lakes region in the mid-17th century and peaked around 1850. And they talk about the Jesuits establishing a mission at Sault Ste. Marie. They talk about the heavy competition amongst fur traders at that mission. They talk about the trading posts that then developed around that competition, and then the union of European traders and Indian women creating descendants, which then created these kinds of communities. There's also demographic evidence the court finds of shared customs, traditions, and collective identities amongst Métis people in that historic period prior to what they call effective European control. So there's, about 150-year history, if not more, of a community of Métis people being there. And remember, I said last time that this didn't just exist in the upper Great Lakes, but also existed in the lower, at least around Lake Huron, at Penetanguishene. There was a huge Métis community at Southampton, Goderich, all around that lower shore of Lake Huron. You get these groups forming as well. Now here in British Columbia, there's arguments that around Kamloops, there were the development of Métis communities in a similar type of sense. In other places in southern British Columbia, Falkland and Greenwood and those kinds of places, Victoria here, right, the communities developed in this historic place. But so far, the court has not found an historic rights-bearing community in British Columbia. Each time it's been tested by the courts, it's been turned back. I have a student, as I mentioned before, Carrie Sloan, who's writing about this being wrong, and she's done a lot of ethnographic research, also analyzed the cases to show what the court's overlooking, but so far not here. Likewise, not in Nova Scotia, New Brunswick, or Prince Edward Island either. Yes?
So the people in Newfoundland, you know, you can tell I'm First Nations. The people I dealt with and spent time with for a week.
Yes.
I
So this is a
couldn't
good
tell.
question. The idea of First Nations is often how we look, right? What's the phenotype of skin color and hair color and eye color is one portion of it, and then sort of behavior of people, maybe attached to language, culture, and certainly that's one kind of measure, and courts do take account of that. We can overstress that though, right? Because it's not just a racialized or a race-based analysis that we're developing here.
Yeah.
It's a political community that's there. And so, for instance, in my part of the world, we've been in contact with Europeans since 1615. Right? And so many generations of intermarriage. In fact, my great grandmother was a Métis woman who married into our community. My great grandmother was a Teresa Riel, who came from this north shore of Lake Huron. She married down into the Saugeen Bruce Peninsula, and so we have Métis ancestry, but we also have French ancestry, having lived amongst French people for 200 years prior to English people coming along, and then we had all the English influence. And so in my area, people often look like me. Right? In another area, people will look darker and have those kinds of characteristics. If you go to the southwest of the United States, Latino influences are so strong in the way people are sort of just presenting themselves. If you go to Nova Scotia, and you find many black Mi'kmaq people. Likewise, down the eastern seaboard with the Passamaquoddy and the Mashpee and the Lenape or the Delaware people, black. You go to southeast United States with the Lumbee people, and again, they present as, they look like they're African American, but they have this political identity because they have this continuity of these relationships in a place with a culture, language, etc. So I really appreciate that you raised that, because it helps us understand why it is that people don't necessarily always look like a certain view of Aboriginal to be able to claim their status. In fact, this is the next part of the decision. Wonderful picture here of this man on the one side who looks maybe stereotypically more Indian, and on the other side there cuts his hair, grows a mustache, and you've got a Métis image that suddenly appears. And the point that the court asks in this part of the judgment is, about the identification of the contemporary rights-bearing community. The court makes the point that the Métis were often invisible, particularly after the Riel rebellions and the discrimination that that Aboriginal peoples faced more generally. So there was a disinclination to be identified as Métis from about the 1890s until, you know, the 1980s. Almost 100 years of going underground and not presenting yourself, passing as British or French to you know, sustain yourself. Because if you identified as Indian or Métis in that period, you wouldn't be hired. You couldn't find a place in the world to be able to pursue your living. And the court says that this lack of visibility has an explanation. There's a rationale behind this. And it does therefore not negate the ability to claim Aboriginal rights because people went underground. Despite going underground, they continue to live in the region. They continue to gain their livelihood from the resources in the lands and the waters surrounding them. They continue to know who one another were, even though they didn't want to tell the world who they were. And so this is quite a significant point, right? That decrease in visibility is not fatal, and that European control in the area did not eliminate their identity. And some of the things that I've discovered about this then have a contemporary application. I have often, through my 24 or whatever years teaching, people who come to law school who know they have an Aboriginal heritage, they know they have family and political connections, but it's not been something that's been talked about in their family, or they've been adopted out, not found a way to be able to make that connection because of you know, being raised in another family that wasn't aware of their status or their Métis identity. And so people come to their Métis, Indian, Inuit status often in their 20s and 30s. And fortunately, that's allowed under Canadian law. You know, Mr. Powley here, their family actually lived on the reserve for many years. That didn't disqualify them. They're visible, it doesn't disqualify them. So individuals are allowed, if they have these connections, to suddenly find ways to thicken them and develop them and then claim that affiliation. It's just that whole communities aren't allowed to spring in existence to know about.
Question. I'm sorry, didn't read it.
Okay.
But freemen, you know, the people who gave up their status
Yes.
when the Indian Act was being put on them, and they had a choice of retaining status and not having land,
Yes.
but becoming a freeman and then being allowed to get a piece of land. What happened to those people?
Yeah, so this is a good question. The point being asked here is that the Indian Act forcibly enfranchised many people if they got an education, or if you got called to the bar and you were Indian, you'd be stripped of your status. You went to war, you'd be stripped of your status. You couldn't be Indian if you did these kind of white Victorian things. And so these people without status who were, the Canadian government called that enfranchised, right? The people would say, I'm disenfranchised now. You know, what about them? Some of those people affiliated with Métis communities and became accepted members of those communities around the Métis settlements in Alberta. We see some of that occurring. Some of those people become what's called non-status Indians, and they don't hook up to Métis communities at some point. So it depends on the particular history of the people. We'll look in about a week or so about this disenfranchisement and franchisement process and attempts to get people reintegrated back into the community through amendments to the Indian Act, etc. So we're going to talk more about that in the future. But for now, the point is that some of those people did affiliate with Métis and became leading figures in the Métis community. Others became non-status Indians and just kind of were out. Just there. There was no protection, no community that they could enjoy as Aboriginal peoples. So what we've done so far, right, is we've talked about the historic rights-bearing community, the contemporary rights-bearing community, and now we want to verify someone's contemporary membership in that historic and continuing rights-bearing community. And here's a card of someone that's in the Métis Nation of Ontario. Just like I have a status card as an Indian, they would have cards identifying an organization and then also their particular community. What the court says is to be encouraged here is the standardization of Métis membership.
Just a question, why does it have an expiry date?
Yeah, my status card has that as well.
Really?
Yeah.
Huh.
I guess they want you to continually come back and just verify or prove or not lose track of you. I don't know. Maybe it's to prevent fraud in some ways, so that just for administrative efficiency purposes, there's not all of these Métis or status cards that are issued and without ever an expiry date. But it's very strange, right? I don't expire from being a Ojibwe in 2000 and whatever. Likewise, Métis people wouldn't either. Good point.
The thing about status cards is they tell me, because I question that, they told me that they want a more current picture.
Oh, okay.
So it every 5 years it lapses, so you have to go and have another picture taken. But you can get 10-year ones. This one's good for going across the into the U.S.
That's right.
But we don't need a green card, so we shouldn't have to have.
Yes, that's right. So there's something called the Jay Treaty in the 1790s when the British and Americans were settling their conflict. There were provisions in that treaty that Indians would be able to freely pass and repass across the border without hindrance. And so ever since that time, the United States has largely recognized that right. So Indians who are status Indians in Canada and can go down and work in the United States without a green card, participate in the affairs of the United States because they're citizens of North America, right? The Haida Nation is artificially cut in half by the U.S.-Canadian border, same with the Ojibwe Nation, many others of these nations. Ironically, the British government, the Canadian government, didn't recognize the thing going in the other direction. So we don't have American Indians coming up here and working like we do in going in the other direction. Although I'm on an advisory committee at Simon Fraser University, the President's Advisory Committee, and those Native students there are trying to get sort of in-province tuition for students that come up who are American Indian from the United States in recognition of the Jay Treaty provisions, that they wouldn't be treated as if they were foreign people when they come to study here.
I wonder if you could just clarify something for me. My understanding was that difference is because that American law, after their hostilities, so the War of 1812, after hostilities, their treaty obligations resume automatically, whereas that British law, the treaties are no longer in force after hostilities unless they're explicitly revived by Parliament again.
Yes.
Is that the...
That's an element of it, right? So after we have different laws of treaties in the United States and Canada as to what would happen in the case of hostilities. In the U.S. case, the treaty just revives and keeps going. In the Canadian case, there is an argument that you would need another ratification of Parliament or another official act to ensure that the treaty is followed. I've heard that explanation. I don't think it's ever been tested in this Jay Treaty context. Another thing is that after 9/11, it got much more difficult for Indians to travel to the United States on their status card, because if you look like Barbara, it's probably easier. If you look like me, you're not Indian. There's this sense of blood quantum that's a part of U.S. Indian law that tries to, in some places, categorize membership. And so the Department of Homeland Security, or whatever the agency is that deals with border crossing, wants to see that you have 50% Indian blood, and that you have a letter from your band leadership to be able to travel on that card and work on that card. So, I worked in the United States under that provision before 9/11 quite easily. After 9/11, I now always make sure that I get a visa when I'm working in the United States, just to make doubly sure, because of the discretion of the border officials. You might have a job, but you might not be able to get across the border to follow that. It's also important to note that the American military has recruited Canadian Indians in great numbers to be able to participate in the armed forces, because there's a young population that's not often having the same kind of opportunities that others might have, and so they go into the military, and then there's that kind of GI Bill where you can get education if you're educated, or if you participate in the military. And so a lot of people have served, yes, in the U.S. military, but then they've also gotten their education in U.S. colleges and then come back here. I think, in fact, could be wrong, but I think Taggy Alford, who is the Director of Indigenous Governance here, Mohawk man, did that. So you'll often find U.S. Army recruiting agents in Indian reserves as a part of that. So we're way off track here. But part of this is encouraging a standardization, right? And the court seeks an objective test to do that. And first of all, they want to see a self-identity. Now, they do say that that self-identity should not be of a recent vintage in paragraph 31. It doesn't need to be static or monolithic. But as I mentioned before, people's identity does come to them through time, and so there's a bit of a tension there. Secondly, the court says there has to be an ancestral connection to a Métis community, a lineal descent somehow, or they might be adopted into the community. That's fine too. So you could be a German child that's adopted into a Métis community, grew up, Métis for all intents and purposes, and if you have that kind of connection, you can still claim the Métis right. The court's not going to insist on a blood quantum as a part of this. And then you have to be accepted by a modern community. And again, as I mentioned, Powleys at one point lived on a reserve in their history. That's not fatal. They even took, I'm not sure if they did, but some Métis people took treaty and had treaty rights for a while, because under Treaty 3, for instance, Métis were provided for in the benefits of treaty. That's okay. You aren't prevented from claiming Métis rights as a result of that process. Questions are, what are the implications of identity standardization? For some people, does that actually defeat the purpose of being Métis, not to be standardized? They want to uphold this, this being between and being free and not being pinned down. There's a bit of an ambiguity in this racialized membership. They say, I guess they do allow adoption in. They don't say we're going to base it on blood, but it's largely about ancestry. And so if you're talking about ancestry, there is some kind of blood connection there. What if a person is removed from the Métis community because they don't like the leadership of their community? What if there's a disenfranchisement of that person, right? So they're no longer accepted by the modern community because they're troublemakers. But what if their troublemaking is actually freedom of expression, and there's a real problem that needs to be fixed in that community? It is possible that that person would find themselves on the outs.
Just
years ago, I found out that I'm free.
Yes,
No idea.
yes,
I just found out, it's like, okay, I don't know what to do with this information.
yeah,
But, you know, like, let's say that I wanted to become, like, really go into that part of my community and learn about my roots and do all these things. But one of the reasons we only found out now was it was this massive shame in my
Yes.
family that nobody knew about and was hid for generations, like my great-great-grandparents. So, would they want to accept me back? How would I prove that I'm willing to do that? I think there's a lot of, like, I'm just using myself as an
Yes.
example, but, you know, acceptance and becoming, coming back to a community and what that would look like.
yeah, you're raising all the important points here that are the tensions in this decision. They say they don't want to see something of a recent vintage, they want to see something that's accepted by the community, but because of the shaming of Aboriginal peoples and the discrimination through hundreds of years, there has been a disinclination to identify. So in the case of Cree, it's maybe a bit easier than the Métis because there would be a community that you could find a tie to often, status or non-status. And my experience in kind of 90% of the cases is that you're going to be welcomed with open arms and come on, let's forge that. Now there are 10% of those instances where your people are going to be like, who are you? You weren't here when we were going through all that hard stuff, and people are kind of, there's disincentives for that joining. So in that context, it's just kind of the politics are there under the Indian side of things to be able to make that re-entry and reinvigoration of identity easier. But on the Métis side, it's a little bit more challenging because the court might say, well, you didn't know about this till 2 years ago, therefore you can't claim a benefit of a contemporary membership, and then the community itself might not accept you, even if you are starting to develop that identity. But I really just want to underline what you said about the shame. I've had so many people tell me that they were told by their mother or father-in-law when they get married, don't tell me when you're Indian. Don't tell me when you're Métis. Your life will be better, your kids will be better if you don't talk about that. And it was like being in the closet somehow to have this kind of identity that you couldn't share that much.
My prospective mother-in-law said to me, what will your kids think? How will they fit in?
Yeah.
You know,
People that you love will tell you that.
yeah.
And it's that era of thinking about Indians, Métis people in a way that's subordinate.
This test for proving contemporary membership, does the court apply this like for Aboriginal rights claims, or is it specific to Métis rights?
This is specific to Métis rights. Yeah. Although you wonder if there's going to be bleed across into the Indian context. Yes.
So, okay, so they want an objective test, but then they talk about self-identity. And so, how is this an objective test at all?
Yeah.
I can't think of anything more subjective.
That's right. So I guess what the court is saying here is that once there's this self-identity, ancestral connection accepted to the community, issue cards, like make statements about who your group is, so put a membership roll together, and then on the basis of that roll or those cards, we can make an objective assessment that you're from this Sault Ste. Marie community or that place. But you're right, underneath all that attempt to show that there's an objective test is all this subjective tension. That's a great question. So, what's the time frame for claiming rights? Did I get this right this time? Post-contact, pre-control, I think I did. And I think we talked about this. Why does this is interesting. Why does the assertion of sovereignty not equal control? Right, so you can have contact as one period to claim First Nations rights. You have the assertion of sovereignty as another period to claim Aboriginal title rights. But then now you've got another time period, which is effective control, which is not necessarily the assertion of sovereignty or contact. That's fascinating from a theoretical perspective, thinking about Canada, that sovereignty has been asserted at one date, but sovereignty actually does not mean control of the parts of the country over which that sovereignty has been asserted. Now, what does that mean in the contemporary circumstances? Maybe you might think, oh, Canada now has control over all of the parts of the country that they've asserted sovereignty. But what about the Chilcotin plot of land that's now recognized as Aboriginal title? Crown's asserted sovereignty there. It is true that they can infringe that title right if they meet a justifiable standard, so that maybe that's control. But in the day-to-day affairs of managing that title by the Chilcotin people, does Canada really have a control there? I don't know the answers to these questions, but some masters, JD student that wants to write a paper on that, is a really interesting view to split up how our country is governed by thinking about control.
So what does it do with treaties and places that have treaties?
Yeah, so often the court says that the signing of a treaty is what gives effective control to the Canadian government.
It's a strange twist on it. So effective control makes you think of international law. It's a term from the law of occupation. So in that context, signing a treaty would be exactly removing effective control in the sense of occupation. It's bizarre.
Yeah, so you get it backwards in signing treaties in Canada. That
Well, that's why I was asking. I was thinking if you sign a treaty, think of the Nisga'a, and they got 5% of their territory. They gave up a large portion, but there's still that piece.
Yeah, that should not be maybe controlled by Canada at that point, right? That's Nisga'a control. That's a good point. Yes.
Why is this time gap not given to Aboriginal rights? Like, why is it about sovereignty? Whereas, I mean, take the Chilcotin. If they were so far away from most white settlements, I mean, why are they not given the opportunity to claim rights up to the point of control? That's
right. So why are Indian rights also not calibrated by this time of effective control? It's arbitrary, is really what we're finding here. The contact in one moment, assertion of sovereignty in another moment, effective control in another moment. When I was giving the lecture on that point, it could have been 1982 as the date by which you would start to calibrate rights, because that's the date of the constitutionalization of Aboriginal treaty rights, as when the clock starts running to prove Aboriginal rights.
Is it divide and conquer?
I don't think it's intentionally divide and conquer. That's the effect of this. I think it's the court struggling to control the floodgates and find some bright lines for when Aboriginal rights, Métis, Indian, etc., can start running. And there was no pre-existing standard that they can identify, so they drew on their own best judgment, prejudice, stereotypes, bias, considered opinions, submissions that they received from the parties. Right? It's made up. So in this case, the court found that Métis hunting is integral to distinctive culture, not prior to the arrival of Europeans, but prior to effective European control, because they relied on these resources. They didn't participate in the economy in the same way as Europeans, where they were, like Indians, largely living off the land, therefore it was integral to distinctive culture. There's a continuity of those rights from the time of effective European control to today. The court finds that these rights are not extinguished. The treaty of the Robinson-Huron Treaty didn't extinguish their rights. In fact, they were excluded from participating in that treaty, unlike Treaty 3. And here, the infringement on the Métis right was not justified because the Crown didn't even think there was a Métis right. So they didn't take any steps to consult and accommodate Métis people to allow for appropriate justification for infringement. And this brings us back to our discussion of just a moment ago. On page 583 of the 683 of the materials, Catherine Bell wrote an amazing article in 1997. She's a professor at the University of Alberta. And she says, I'm just going to read a paragraph or two here at the top of the page. A consideration of both ancestral origins and legal origins takes a comprehensive rights analysis beyond rights sourced in racial descent to rights sourced in essential attributes of peoplehood or nationhood. Adopting this approach, a proper interpretation of rights in section 35.1 is one which places equal emphasis on the words Aboriginal and peoples in assessing the origin, scope, and content of the right. In the next paragraph, she says that the word peoples is frequently referenced in international political discourse, that the meaning in international law that the framers of the Charter knew about was that peoples had a self-determination component attached to it. So she says, drafters knowing about the United Nations Declaration of Human Rights, knowing that self-determination attached to peoples, should have known when they used the word Aboriginal peoples in section 35.1 that we're channeling that kind of self-determination. But notice what the court has done here and what the court did in the Vanderpeek test. We spend a lot of time talking, what's the Aboriginal qualities of these guys? Right? Is it that they're hunting moose? Is it that they are living off the land? Are they doing the things that we kind of stereotypically consider to be Aboriginal, you know, as it was once upon a time? But if you would have taken the standard of international law, what are peoples? How are they characterized, construed? What rights attach to that kind of consideration? We wouldn't be dabbling in history. Right? We would have a whole other way of defining section 35.1. It's so far the path not taken. It's like, it's reading like this. The existing Aboriginal and treaty rights of the Aboriginal of Canada are hereby recognized and affirmed. Silence on peoples. And maybe Daniels will get peoples more firmly in the framework of section 35.1. There's certainly a couple of interveners that have made that point. Both the AFN and the Chiefs of Ontario said define Métis as peoples. And Justice Brown asked a question of the AFN lawyer in this Daniels case, and the lawyer said, leave self-definition to us as Métis, as Inuit people. That's our right to define who we are as self-determining peoples. And Justice Brown said, well, there's nothing for us to talk about then, if that's your standard. Because the point is, you know, who are Indians under section 30 or under section 9124? Kind of a tension there, right? 9124 says Indians are something. 35.1 says Aboriginal peoples of Canada are Indian, Métis, and Inuit. So on the one hand, there is a need for a definition by the federal government, provincial government, courts. But on the other side, there's a need for peoples themselves to say who we are, and then their hope is that the Crown and courts would accredit their own understanding in that fashion. So who gets the power of self-definition is what's here, and there's a tension in that. I think that's the Powley case. Any questions there? So we're going to do what we've always done, which is run out of time. But at least we have 20 minutes for this next case, which is the Manitoba Métis Federation case from the Supreme Court of Canada in 2013. And so you can read about this group. We follow the links that are there in this PowerPoint presentation. It's on your course spaces. These people are affiliated with the Métis Nation more generally. They're obviously a Red River-based organization. They are not like the Powley community that has a different kind of ethnogenesis. They're out of that issue that we talked about last time. Now here's the architecture of the case, and if you have your course space open, this is worthwhile just keeping on your desktop as we talk, because you can see how complicated it is with 153 paragraphs. What the issue is here is when Métis people negotiated with the federal government through the Métis provisional government, there was an understanding of how Métis rights would be treated. That's why they prevented the Governor General and surveyors from coming into their territory. And with this negotiation that the provisional governments engaged in to bring Manitoba into Confederation, there was a promise that 1.4 million acres of land would be set aside for the Métis people to give them a head start in claiming their place on the land as settlers from other parts of Canada, other parts of the world would gather to the prairies. What the issue is here is that the Métis Federation is claiming that that negotiated promise that they received from Ottawa, that they voted to accept as a provisional government, was not fulfilled. That promise that they received from Ottawa, which was also put into both Canadian legislation and constitutionalized, is something that's not been fulfilled. Because they say that 1.4 million acres of land was never set apart for them in the way that they understood it to be set apart. So this isn't a treaty that they negotiated in the government size, in the court size, to get this land set aside and get it protected by the Manitoba Act, but it's treaty-like, right? And the Manitoba Métis here are saying the federal government has breached our treaty-like promises that we received from you. They actually use the word treaty. They say you've breached our treaty. The court doesn't want to characterize it as a treaty. They're going to characterize it as a constitutional promise to the Métis to help them get that head start. And again, the Métis people are saying that was violated because the land wasn't set aside, settlers flooded across our territory, and we were booted out. And so that's why we ended up in North Dakota, Minnesota, Saskatchewan, Northern Alberta, British Columbia. That's the cause of the diaspora, is the fact that our homeland wasn't protected. So that's the issue in the case, is whether or not Métis have rights. Can they get a declaration that the federal government violated its constitutional promise by not setting this land aside? And they make three arguments in this regard. One, they say the federal government breached a fiduciary duty to the Manitoba Métis, to the Métis Nation, by not setting their land aside properly as they thought it should be. They also, and they don't succeed on that. The court doesn't agree that there's a fiduciary duty that the government had to the Métis to set aside lands in a certain way in accordance with these promises. They make a second argument, which is the honor of the Crown is breached because this land wasn't set aside in a way that accords with the constitutional promise. And they do succeed on that point. There's a third claim they make which they don't succeed on, which is all the statutes which were in place to implement the Manitoba Act of 1870 which was that constitutional promise, are ultra vires the province because they didn't sort of properly fulfill this federal obligation. And the court's not going to accept that argument. They say that's moot. Those statutes are done. They're in the past. There's no live issue there that we'll consider. So the Manitoba Métis Federation failed to get a declaration that there was a fiduciary duty that the Crown had to protect their land. They fail in challenging the constitutionality of provincial statutes in implementing the Manitoba Act. But they succeed in getting a declaration that the Crown didn't act honorably in the fashion or in the way that those lands are set aside. So that's the case in a nutshell. Any questions about that? Like that's the, trying to just give you the simplified form so you can follow along. Okay, so then the case architecture is going to have us ask different issues about this claim it says raise. First of all, there's a question of the standing of the Métis, Manitoba Métis Federation to even bring this case. Right? Are they the proper party to be able to raise the derogation of the Crown's obligation? And the court's going to say, yeah, they're okay. They're the proper party. We'll look at that. Then there's this argument about why Canada does not owe a fiduciary duty to Métis people. So they're going to talk about when a fiduciary duty arises, which is based on 2 points. One point is when there's a specific interest that can be protected in law. And the court's actually going to find that the Métis did not have an Aboriginal title interest to their land, and therefore no fiduciary duty could flow from that. The Métis didn't have Aboriginal title, and so there's no fiduciary, there's no specific legal interest. It's like that trust res kind of thing that we were talking about when we briefly talked about the Garan case. There's no legal right that the Métis possess in this land to which a fiduciary obligation could attach. But there's a second possible argument for when a fiduciary duty arises, is when the Crown makes an undertaking. When the Crown makes a specific undertaking to an Aboriginal group, that could also give rise to a fiduciary duty. But the court's going to find that there is no priority undertaking given to the Métis people here, because when Manitoba was being set up, yes, there was promises to the Métis about their land, but there was also the intent that this land would be opened up to everyone else too. And so the Métis are intermingled with all other future Canadians that will settle in that site. And so there's no specific undertaking to the Métis about their land because everyone was going to get some land if they followed proper course. So no fiduciary duty arises as a result of those 2 arguments. There's not a pre-existing legal interest, and there's not a specific undertaking that's separable from the other undertakings that the government was giving just everyone that wanted to live there.
It seems it should ring bells for the court that contradicts their view on Aboriginal title. Because the same thing that they say there is a fiduciary duty because there is Aboriginal land, but the Crown must manage it with the best interest of the broader public in mind. So
Yes.
I think that way of managing land in the broader public interest undermines the existence of fiduciary duty. It should do so also in the case.
That's right. But so that should raise bells, but the challenge that flows here is the court's not willing to say that this is Aboriginal land prior to it being identified in the Manitoba Act as 1.4 million acres that the Métis people should get. So yeah, but you would...
But according to its view of managing in the broader public interest,
Yes.
then what it says here would undermine the existence of fiduciary duty even when there is Aboriginal.
That's right. That's right. Yeah, you should be able to manage in the general interest and the second point of undertaking at the same time as consider what the Aboriginal interest is there. It's not contradictory to take the public interest into account as well as the Aboriginal interest, is what you're saying. And here the court is not allowing that to sit together in this instance. That doesn't seem to accord with the other framings. So they don't succeed on that point. They do succeed on this honor of the Crown test. They talk about what the principles of the honor of the crown is, which is high dealing. When is the honor engaged? Always. It's for the purposes of reconciliation. What duties are imposed by the honor of the crown? Duties vary with the circumstances, just like in the, they vary with the circumstances. And a new duty is going to be added here, which is a duty to act diligently to fulfill the purposes of the promise. That's new. That's going to help, obviously, Aboriginal Métis people in other contexts. It's also going to help Indians in other contexts. Because right now, there's a lot of foot dragging on implementing the modern treaties. And now there's law that says the honor of the crown has to diligently implement and fulfill its promises. There's a reason for doing it. Toot sweet kind of thing. Manitoba Act, Section 35(1) shows that there was a failure to act diligently. Manitoba Act created a duty to act diligently. There were solemn promises, act diligently. There's this other section to set aside land. For all people, the Crown says that honor is not engaged in that instance. So why did the Crown not act honorably in implementing the Manitoba Act? Because they delayed. And they talk about kind of like 15 years of delay that resulted in the Métis not getting their land, not counting the population properly, change in government, poor census taking, change in statutes. There's just all these things happening on the ground that didn't get the act done. And that delay compromised the ability of the Métis to get the effective 1.4 million acres of land. It also facilitated speculators' sales. Because Métis people weren't getting the land, they got scrip, which is the next point. And that scrip often was half of the value of what you'd be able to get from the land. So the delay created a market in Métis land. And that market in Métis land was kind of was damaging to the Métis interests. It diminished or diluted the value of their land. It diluted their opportunity to take up that land. So the Crown's honor was negatively impacted because of speculators getting in because of their delay. The Crown's honor was negatively impacted because of the scrip system not effectively implementing the promise that they received. There was a random allotment of these lands as well. The Métis made the case that, well, we wanted all our lands to be joined together like in one big reserve, a reservation. The court said, no, at the time the Métis did not view their land that way. They were quite happy to alienate it, take the best land, particularly the English Métis, take whatever was the highest value land. They didn't care if everyone was living together. The French wanted to live more together. The French Métis wanted to live together. But that random allotment was in accordance with the Métis preference and way. Therefore, that's not a violation of the honor of the Crown. These other points, delay, speculator sales, scrip, were a derogation of the Crown's duty there. Talked about those other statutes that were given to implement the Métis Act that the province passed were contrary, were moot. So the court is not going to ask whether or not they were ultra vires when the province is trying to implement this federal constitutional promise. Then the last 2 points in the decision are the Crown, in right of Manitoba, raises the point that there are limitation periods for you to be able to raise claims of fiduciary honor of the Crown, and which is in the statutes. Through the years, Manitoba's past statutes create settled affairs. If you don't raise your issue in time, you can't raise it in the future because of a statute of limitation. Likewise, sometimes there's lashes. Equity says you can't bring a new issue forward even if there's not a statute of limitations, because it would be unfair to those that have vested third-party rights in the meantime. And the court rejects both of those arguments. It says limitation periods don't preclude a declaration that the Crown breached its honor here, because the court always has control constitutionally to measure whether or not parties have been acting in accordance with our highest values. So now there's a limitation period cannot defeat a constitutional obligation. Yes?
Yeah, I've read this as sort of potentially a way around the Chippewas and Sarnia analysis, whereas in Chippewas the court, of course, applied doctrine of latches and bona fide purchaser for good value, the equitable defenses, and sort of relied on those to refuse to make a declaration of title.
Yes.
I wonder if this analysis provides us a way around that, where the matter can be characterized as being constitutional in nature.
That's right. So this case that's being referred to is the Chippewa v. Sarnia's case, which was a case out of Ontario, southwestern Ontario, in the 1980s and 1990s. And the issue was some land was surrendered by Indians, Chippewa people, Anishinaabe people, to a private third party. It wasn't surrendered to the Crown. I mean, you know that that's contrary to the Royal Proclamation. You can only give land as Indians to the Crown. But in this case, it went to third parties. And then those third parties started using that land, eventually registered the interests in the land registry office. And then the Chippewa v. Sarnia come back all these years later and say, that land's still ours. Because constitutionally, we can't give land directly to others. And the court says, technically you're right. That is Chippewa land, that's Anishinaabe land. The way it was given is contrary to Canadian, British law. So far so good for the Chippewa v. Sarnia, not so good for those people that were living in that plot of land that is now questioned by the court. But the court says, even though that was contrary to law, contrary to the proclamation, there's statutes of limitations, and particularly the latches or the equity of the circumstances would leave that land vested with those third-party owners. So they get the land, that is the non-Aboriginal peoples get the land, non-Aboriginal peoples, despite Aboriginal peoples technically being vested in them. It's defeated on lashes in this case. Now the question here is, that's only a Court of Appeal of Ontario case. If there was to be another litigated case where a third party possessed something inappropriately by receiving it directly from Indians, not going through the Crown, could the court come along and then say, actually, the equities of the situation are that you can't defeat Indian claims through limitation periods. You can't defeat Indian claims just because it's been a long time running. So this maybe opens the door to that. Now the other wrinkle in the Chippewa v. Sarnia case is that it appears as though the Chippewa v. Sarnia acquiesced to the transfer directly to third parties rather than giving it to the Crown. And because of their acquiescence, the court said we can't allow equity to benefit them as Chippewa people. We're going to allow equity to benefit the non-Aboriginal purchasers. That doesn't lose you in the detail of that case. Let's just take it back. What's the message here? Constitutionally speaking, long periods of time do not necessarily defeat Aboriginal claims. It doesn't necessarily defeat it through limitation periods. It doesn't necessarily defeat it through lashes. Now, there's a special circumstances here, is all these people though are asking for is a declaration, and by asking for a declaration, no individual rights on the ground will be affected. If there was, you know, declaration of title over private land, where a third-party interest would be compromised, the court might not be so generous. In fact, there's some even wording to that effect in the judgment. So I have a whole PowerPoint that goes through each of those issues, but we're just about out of time. But I think we've covered it, and the PowerPoint will go through chapter and verse to help you work out the answers to these questions. I think I should just ask if there's questions you might have about that overview I've given.
I have a question about remedies. So, because there's no recognition of fiduciary duty, what's the remedy available to them?
So the remedy is only this declaration that the Crown breached its honor by not diligently fulfilling its promise. What's the value of that? Nothing in terms of specific things changing on the ground, but they want it nevertheless because they're seeking to reconcile their relationship with the federal government. And the Métis, Manitoba Métis Federation says that will help us in negotiation. So we need this declaration as a point of negotiation to help us reconcile. And the court says, yep, reconciliation, that's a constitutional value that we're going to give effect to, and so the declaration can issue as a result. But on the ground, Métis don't get an inch of soil back through this declaration.
What if if there was a recognition of a fiduciary duty here, would that have given rise to?
Yes, if there's a recognition of a fiduciary duty, that would have given more teeth, because there would have been an interest that had been violated, that then damages arise. The Guerin case that I talked to you about, when there's unconscionability in the Crown's conduct, they don't follow through the protection of the interest that's vested in the people, that there has to be remediation remedy in that instance. But we don't get that here, because because the Métis people did not possess, even though Johnny MacDonald said Indian title when we were referring to Métis title, and even the Métis people were saying we have Métis title, Indian title, the court's not willing to say that these people have Métis title, because they say you guys didn't organize yourselves communally prior to contact. Well, communally, I guess, in the way that other Aboriginal peoples organize. So the court has a view of Aboriginal title which is communal. Now there are Aboriginal peoples that have a very strong individuated sense of how their title should be held within their group. Right?
So when you think about places where women carry the inheritance,
Yes.
and they marry a white man,
Yeah.
way back when, shouldn't we go back to what I asked the other day about having having the right to have status again?
Yeah. So in this instance, the court doesn't like to think about Aboriginal peoples having land in severalty, having land that is kind of like we hold land, where there's individual responsibility for different parcels. This is what counts against the Métis people here. And yet, Aboriginal title in many British Columbia contexts is, yes, communal in one sense in that it's territorially held, and there's a recognizable nation there, but within that territoriality, there's a lot of individual, even libertarian ways of thinking about property within their systems, and these people lose out because of a sense of a communal nature of title that doesn't accord with their thought of, well, everyone just must be equal together holding this land. It's like a commons. Aboriginal title is not commons land within Aboriginal societies. There are responsibilities and ownerships within that, and this way of thinking about Métis title just doesn't get at that. We've taken too much time. Next class will come and deal with federalism, I think. So we'll see you next Monday.